Good afternoon, everyone. So once again, thank you very much for taking an hour from your busy schedule today. My name is Rathin Sinha. I am the founder of JOBfindah Network and the moderator for today's webinar. I'll make the introduction and, time permitting, take questions and pass them to our presenter. Today's webinar is hosted by JOBfindah Network. Organizations throughout the country use JOBfindah for easy-to-use job posting, distribution, outreach, and reporting for federal contractor OFCCP compliance and diversity recruiting. In addition, businesses use JOBfindah services for customized solutions to power and enhance their recruiting results. Today's session is strictly a session for learning. There is not any sales pitch of any kind. Our industry changes very quickly, and from time to time we get industry experts to speak and present in front of you. As you know, the recent COVID-19 pandemic has slowed much of the country. I can pretty much presume that most of you are working remotely today instead of going to your office. So it has kind of changed how we work, and also several changes in the regulatory environment. Despite all this, the OFCCP has been as active as ever by scheduling audits, releasing CSALs, issuing new directives, and much more. The OFCCP has ensured that federal contractors remain vigilant even while dealing with the greatest crisis in generations. So in today's webinar, our speaker will address these issues such as audit deadline extensions, virtual on-sites, and much, much more. As a frequent speaker for us, Matt Camaradella needs no introduction. Matthew is a principal in the Long Island, New York office of Jackson Lewis P.C. He is the co-leader of the Affirmative Action Compliance and the OFCCP Defense Practice Group there. Matt directs preparation of more than thousands of AAPs each year and defended hundreds of audits for a broad range of employers. He also serves as the practice group lead on responding to OFCCP allegations of class-based discrimination. He is known industry-wide, and I hope you learn a few things in today's webinar from him. Finally, please, send your chat, help others. I know somebody has written a note about it works fine with Chrome and not with Internet Explorer. So I just wanted to let anybody know, if you're having an issue, you might want to try the Chrome browser. As I mentioned before, we'll make a copy of the presentation as well as have recording of it within 2 days. Give us a couple of days just to make sure. We also are approved for an hour of HRCI, HR Certification Institute credit. No SHRM credit, we're still working on that, but HRCI credit is there. We'll send you the information for that. And if we do not get enough time to address all the questions at the end, please do send them to me, Rathin Sinha at JOBfindah.com, or to Matt directly. We'll be sharing the contact information. So without taking any further time, let me hand it over the microphone to Matt. Matt, it's all yours.
Thank you, Rathin. Thanks, everyone. So glad to be here with you. As I was thinking about today's webinar, I realized that, I'm a little rusty because ordinarily I am out there in the public space speaking at various events, whether they be conference or industry group meetings or whatever the case may be. And since all of this happened in, I guess, March, I have been grounded. So it's good to flex my presentation muscles again, and I'm very much pleased to be with you guys today. So for about the next 50 minutes or so, we're going to talk about the topic of OFCCP compliance and really what is a new world, right? This is a post-pandemic or I guess in the midst of pandemic world. And so things have changed for sure, but your compliance obligations have not. And any of us in the compliance arena who was worried about job security when all of this went down, rest assured, if you have responsibility for affirmative action compliance in your organization, the OFCCP has not missed a beat. And we're going to focus on what we can continue to expect from the agency at this point in time. So with that, we have some major agenda items that we're going to cover in our discussion today. We're going to talk about audits and the scheduling of those audits and what the agency's up to as far as conducting reviews. What the OFCCP has done explicitly as a result of the COVID-19 pandemic. We're going to talk about Section 503 on-sites as one of our focus areas. And the reason for that is because we've learned over the last 6 to 9 months what those really look like, how they have taken shape over that time frame. So we're going to share with you some of the learnings that we've had from those. And in particular, how the agency has started to pivot to a non-on-site on-site, if that makes sense. We're going to talk about 3 new directives that were issued at the beginning of this calendar year, right before the pandemic struck. And then we'll just briefly touch on sort of what to expect in the future. And now nobody knows exactly what to expect in the future. And while I do have a crystal ball that I keep in my office, sometimes a little bit hazy, and this is one of the times that is the case. But we'll do our best to give you a sense of things to come. All right, so first things first, we are living in strange days, my friends. This is something that honestly I never really envisioned. On top of what was going to be an exciting 2020 because it was an election year, we now are faced with a challenge for the generations. And that is this COVID-19 pandemic, which emerged right about the beginning of the year and has grounded so many of us and the businesses that we work for in this country as we grapple with its impact. And as if that weren't enough, we are also in the midst of a period of civil unrest in this country that we haven't seen in, again, a generation or two. And so some of you are probably old enough to remember the Rodney King situation out in LA. And I imagine some of you may also be old enough to remember some of the unrest around the time of the Vietnam War and the time when they were pushing for the Civil Rights Bill in Congress. I was not old enough to remember that, as I was not born yet, but I certainly remember what happened around Rodney King. And at least from my experience, what we're seeing here is something that this country has not seen in a long time. So we are roiling in a lot of uncertainty, a lot of stress, a lot of concern for ourselves, for our neighbors, for our friends, for our families. And in the midst of all of this, who's thinking OFCCP compliance, right? Well, the fact that we have well over 140 people here on this presentation today, I guess a few of us still are thinking about it. And that's a good thing, because the OFCCP has, as I mentioned before, they really haven't missed a beat. They've changed the way they do things, but they are still enforcing their mandate, which is ensuring equal employment opportunity, non-discrimination, and affirmative action from federal government contractors and subcontractors. All right, so that's what brings us all here today. All right, so let's talk about our first topic, which is audit scheduling and CSALs. So OFCCP has not stopped conducting audits because of the pandemic, and certainly not because of the civil unrest that we are experiencing in this country. The agency is kind of like a clock. It keeps ticking, no matter what the case may be. And we've seen the agency in 2019 at two different points issue what's called a courtesy scheduling announcement list. All right. So the CSAL, as it's known, is, for those of you who may not be intimately familiar with it, a list that the agency generates at different points in the course of the year. And that list is made up of federal government contractor and subcontractor establishments that the agency intends to audit in the relative not too distant future. Now, time from the government's perspective looks very different than our perspective of time. So when we think of soon or in the not too distant future, we're oftentimes thinking days, weeks, months. In the agency's case, it's months and years sometimes. The earlier of those CSALs that was listed in March, the agency is still working through. All right. In fact, that is where the majority of the audits are coming out of right now. All right. And that CSAL broke down the contractor establishments into different categories of reviews, depending on the nature of that particular establishment. So the agency, off of that CSAL list, was scheduling standard compliance reviews, so typical audits that most of us are used to. They were scheduling corporate management compliance evaluations, so those are audits of corporate headquarters. They were scheduling compliance checks, so these are more streamlined type audits that involve just the inspection of a few documents. And then Section 503 focused reviews. All right. And so each of the establishments on that CSAL was designated to a certain type of review, and that's what the agency is currently working through. There were 3,500 of those that were scheduled. Now, in addition to that, in November of 2019, the agency issued a supplemental CSAL, and on that CSAL, there was a much more limited number. There were only 500 contractor establishments listed there, and every one of those was designated for a VEVRA-focused review. So a focused review of your compliance with the affirmative action regulations governing veterans, as opposed to minorities and females under an executive order affirmative action plan, or individuals with a disability under a Section 503 focused review. All right. So as I mentioned, the agency is working off of that March 2019 review, and they had plans on doing these VEVRA-focused reviews, but they hadn't gotten approval yet to issue the standard letter initiating that audit. All right. So the Department of Labor is required, really any federal agency is required to get Office of Management and Budget approval for any form request for information. That one of the affirmative action plans. So if it's a Section 503 focused review, it's exclusively focused on your plan covering individuals with a disability. If it's a VEVRA-focused review, that audit is exclusively focused on your adherence to the affirmative action regulations covering veterans, all right? So because of that, those reviews are more limited in some respects because they're not looking at all three plans. And importantly, they're not looking at all of the statistical analyses that typically make up a regular audit because of the inclusion of the executive order plan. So things like adverse impact analyses and compensation analyses, those things that give us the most concern. But they also are a little bit more extensive because they are a deep dive into our compliance in those areas as opposed to more of a surface review. And every one of these focused reviews requires an on-site, right? Regular establishment reviews, right? So standard compliance reviews. The need for an on-site is on an as-needed basis, right? So there has to be a justification for going on site. So usually it's some sort of indicator, statistical or otherwise, that there may be discrimination occurring, typically in the area of hiring or compensation. And so as a result of that, on-sites are actually very rare in the context of a standard review. However, for our Section 503 and our VEVRA reviews, they are mandatory. All right? Matt, yes, please.
Yeah, just wanted to interrupt you. A couple of things. One is there are a few questions. You can see if you want to take them now, we can come back later. Another thing I just wanted to let everyone know that sometimes you might see that you are disconnected. If that happens, just wait a few seconds. It will get you back to the line. It has happened to a few people. Don't, it'll just come back. I think it's an internet connection issue, or it can be also some issue with the platform. But otherwise, just give it a few seconds or a minute or so. All right. Sorry to interrupt.
No, thanks for that clarification. And I'll quickly take a question that popped up on the chat box because it's particularly pertinent to this. And that was, if you're on one of these lists, right, does that mean you're going to be audited? And the answer is probably. In all likelihood, you will be audited. But there is no guarantee. All right. So if you're on the VEVRA list right now, they haven't begun commencing those reviews. And so as a result, you're not going to see an audit probably for a few months off of that list. Maybe not even before the end of the year, as the agency continues to go through the 3,500 from the March 2019 CSAL. So just bear that in mind. But in our experience, over 90% of those establishments that are on the CSAL do, in fact, ultimately get audited. And then the last thing I'll point out real quick here is that the agency has done a lot to put information on these types of reviews up on its website. So I have a link here, for example, to the VEVRA landing page. But you can see the scheduling letter. You can see lots of FAQs related to these types of reviews up there. So one question that I've received fairly frequently, because it happens every year, is will there be a CSAL issued in 2020? And I can't answer that question with any certainty. But again, if history is any guide, we will likely see something, but I suspect it would be before the end of the year or by the end of the year. I wouldn't expect anything soon because the agency hasn't gotten through that many of the reviews that it wants to conduct based on the 2 CSALs that were issued in 2019. In fact, as of the time that we were putting this deck together, the agency hadn't even gotten through half of the 3,500 in the March 2019 CSAL, and as I mentioned before, they've gotten to 0 of the November CSAL. So again, if you're on one of those CSALs and you haven't seen a letter yet, it doesn't mean you're off the hook. It just means that they haven't gotten around to you, all right? So be on the lookout. Now, one quick item I'll point out here before we move on to the next topic is for many of our organizations, we are not staffed the same way on the premises, right? So you may not have people in the office, may be forwarded places. The OFCCP traditionally schedules audits by sending you a letter, hard copy letter. And so it is important that whatever process we have in place to collect mail, that mail doesn't sit for an extended period of time because the clock starts ticking from when the letter is actually received. Now, the OFCCP has made efforts to reach out to contractors who are on the list to find somebody who will accept an electronic version of the letter, just so that problem doesn't occur. But it would be smart for us to be vigilant and paying attention to the possibility that we may be getting a hard copy letter. Okay, so the next topic that we're going to cover is what's the OFCCP doing given the fact that we are currently experiencing this worldwide pandemic? Well, they are taking steps to make our lives easier. So the first thing I'll address, and I'm not sure how applicable this will be to the folks on this particular call, but it may, and that is the agency issued a national interest exemption at the beginning of the explosion of this pandemic in this country. And specifically, what that exemption did was it excused the inclusion of the affirmative action contract provisions in contracts that were entered into after the issuance of the exemption for a 3-month period for specific contracts that were entered into to address the coronavirus. So, for example, let's say you are a medical device provider and the National Institutes of Health needed 50,000 ventilators. And they came to you and they entered into a contract to purchase those. That would be specifically to address the coronavirus emergency, right? And if in that contract for that purchase, the provisions that normally would show up in that contract related to affirmative action compliance would not be there, right? So that contract would be exempted from the affirmative action requirements. So, but understand this has limited application, right? It would mean that that medical device provider is not otherwise a federal government contractor or subcontractor that is subject to those requirements, right? So it's sort of for that one-shot deal, right? I make ventilators. I've never sold one to the federal government before. Now I've sold ventilators to the government. Ordinarily, that would subject me to contractor status and these affirmative action obligations. But in this case, because of the exemption, those requirements will not be there, right? Just for that contract. Now, if I'm already selling ventilators to the federal government directly or indirectly, and I happen to enter into another contract explicitly to respond to the coronavirus emergency, while that contract would be exempt, my other contracts are not. So I continue to be a contractor subject to these regulations. And so that's the national interest exemption. It also does not exempt discrimination charges. So if an employee or an applicant wanted to file a charge with the OFCCP, then they could continue to do that, and the OFCCP would have jurisdiction over that employer, even though the affirmative action requirements do not apply. So that's the national interest exemption. What I suspect is much more pertinent to this group is the submission extensions, right? So ordinarily, and I mentioned before, that the OFCCP commences the time frame for responding to their scheduling letter when that letter is received. And ordinarily, you would have 30 days to submit a copy of your affirmative action plan to the agency, right? Due to COVID-19, the OFCCP will grant an automatic extension upon request. All right. So in that particular in that particular circumstance, you could, upon receiving the letter, ask the OFCCP for that extension, which means you would have 60 days in which to submit your affirmative action plan. Now, in addition, something that pre-existed the coronavirus was the agency was allowing contractors to split their AAP submissions. So you could submit the basic AAP within 30 days and all of the supporting documentation on the itemized listing attached to the scheduling letter 30 days thereafter. So everything needs to be submitted within 60 days. So if you asked for that extension for the support data, you could in fact receive a 30-day extension. With this automatic 30-day extension on the front end, the basic AAP now becomes due after 60 days, and the support data becomes due after 90 days. All right. Now, what's critically important here is that the extension has to be requested. All right. So that's important, right? It's not going to be given to you automatically. So just pay attention to that. If you are being audited and you want that additional time, make sure that you ask for it. The other thing that the agency is doing is they are giving contractors a break in responding to requests for information post-submission. So it's not uncommon for the agency to ask for additional information after the initial submission, and oftentimes those requests are fairly aggressive in terms of timeframes. Oftentimes it's 5 days, 10 days. So the important thing is that you communicate with the agency, right? If you have a request for additional information and you need more time to submit it, just make sure that the agency is aware of what you need, and in all likelihood, they will grant it to you. A couple other things that the agency has done to try to make contractors' lives easier is they've streamlined their FAP application process. So those of you familiar with FAPs, or functional affirmative action plans, in order to use a FAP structure as opposed to an establishment-based structure for your AAPs, you need to apply for permission with the OFCCP and enter into an agreement to that effect. That process, while they've tried to streamline it in recent years, is still fairly onerous, right? The application package is fairly substantial, and the back and forth that takes place once that's submitted with the agency can be fairly lengthy. And it typically would involve an in-person meeting with the agency to review the application package. The agency is waiving that in-person meeting and doing everything virtually in an electronic means. All right. So if you are interested in doing a FAP, but you weren't sure how this COVID-19 would impact the agency's ability to process applications, they are processing applications, and they're doing it in a more virtual environment. The last thing that the agency is doing is recognizing that they're not hosting technical support or compliance assistance programs in person the way that they were before, is they are still trying to reach out to the contractor community, but they're doing it by providing essentially a self-service module, right? So on the OFCCP's website, and I've included some links in the presentation that you'll all receive, there is a virtual help desk and a contractor assistance portal. Both allow you to ask questions and solicit information, or take advantage of information that is already posted there to answer questions that you have. But the help desk is very, very responsive these days. If you send in a question, you may not get your question answered very, very quickly because it may be complicated and they have to go through levels of review, but you will receive a response quickly, letting you know that they are looking at your inquiry. All right. So I think that covers that subject. So why don't we move on to the Section 503 on-site. And this is probably the area that we've seen the most substantive development over the last 6 to 9 months with the agency. These Section 503 focused reviews are a fairly recent phenomenon, right? The first time that any of these were noticed, if you will, was in that March 2019 CSAL. And the agency didn't really start scheduling those until May of 2019. So those were the earliest of those reviews. Given how long reviews typically take, it's not surprising that we are seeing that the on-sites really just started getting going. Fortunately, with the volume of audits that me and my team are involved in, we've had the opportunity to participate in numerous OFCCP on-sites. So we wanted to share with you just some of the things that we were gleaning from our experiences there. All right, so the first thing is how long? Well, the OFCCP originally envisioned that they were going to do these on-sites for a week. Not only were the contractors dismayed about this, but the rank and file compliance officers at OFCCP weren't too thrilled either. So what we're actually seeing is the average is 2 days, right? It may not even be a full 2 days. We've seen some push into a third day. A lot of it depends on how many people are being interviewed. The agency, if they are on site, typically will commence the on-site with a facility tour. And it's brief, right? It's pointed and it's aimed at 2 things. One, they want to see that the required postings that under the affirmative action regulations are where they're supposed to be. So this is your EEOs, the law poster and supplement, your pay transparency poster, your notice of union rights, those sorts of things, all right? So ordinarily the agency would make a beeline for wherever the employment postings are so that they can see those. In addition to that, the agency also wants to observe the accessibility of the facilities themselves. So the entrance, if there's multiple floors, if there's an elevator by which people can navigate the floors. What about the bathrooms? Are the bathrooms accessible to somebody with a disability? And then the major focus is on those things, those employment practices that relate to the disability regs themselves. So your hiring process, specifically your outreach and recruitment directed at individuals with a disability, your accommodations process, what your leave policies and procedures look like, and how you're assessing the effectiveness of your outreach efforts. So this is important to understand because this is the meat of the OFCCP's focused review. I think it really lends itself to a checklist, right? A checklist that mirrors the regulations and that you can periodically look at and basically check off the last time that it was done. We've actually developed something like that for a number of our clients. So if you are interested in seeing a template checklist to that effect, I'm more than happy to share it. You can reach out to me after the webinar with contact information. I'll be more than happy to send that on to you folks. But it's a great self-diagnostic tool for you to use. One thing I want to just quickly focus on here is accommodations, all right? So many employers that we work with do not do a particularly good job of tracking requests for accommodations and the outcomes of those. And there's a reason for that, is because generally speaking, that process is not centralized, right? So they don't necessarily know who did what when. It's important to try to consolidate and centralize those requests, not to take away the authority of rank and file managers to accommodate employees, but just so we have a centralized location or repository for all of those requests so we know what happened. One of the standard requests you will get from the OFCCP in these focused reviews is a list of each accommodation requested, what the outcome of that request was it granted or not, and if not, what was the reason, right? So you'll definitely want to make sure that you have a process for capturing all of that. The other thing that the agency is going to focus on if they're on site for one of these 503 reviews is the experience of the employees, right? So those people who administer policies and those people who are subject to policies. So the agency will typically ask for a list of individuals who self-identified as being disabled. And they will want to interview, depending on how many of them there are, all for a representative sample of those folks. Those would be confidential interviews, right? So we would not participate or be represented during them. But they would also interview managers, right? And they want to interview managers for a couple reasons. One, what is their awareness of the company's policies and procedures around disability and accommodation, right? What does the process look like? If an employee were to come to them and say, hey, I need assistance or I need an accommodation or whatever the case may be, what does that process look like, right? So when you think about those types of interviews, number one, as managerial interviews, we get to sit in on them. But number two, we get to really prep our managers and make sure that they understand these policies and procedures. So one of the takeaways in all of this, if you're managing an OFCCP on-site for a focused review yourself, make sure that your managers are prepped for those interviews. All right. Now, as I mentioned before, we are currently experiencing the no on-site, right? And that's because the agency right now is 100% telework, right? So all of the rank and file staff work from home. They are not permitted to travel. They are certainly not permitted to go to contractor establishments, but they are still expected to complete their reviews. So they've moved to virtual on-sites. The nice thing about virtual on-sites is there's a lot of flexibility in terms of what takes place and how it takes place, the timing, etc. It has much less of an impact on your day-to-day operations as if in comparison to when they are actually physically on site. On the other hand, there's maybe less control. You feel like you have less control over an on-site when the agency is doing it all remotely. But what the agency is essentially doing is they're going to request all of their documents, all of the information that they would ordinarily request on-site be sent to them electronically, and all of the interviews will be scheduled to be done via video or teleconference. But your takeaways are the same, which is make sure that your managers are prepped for their interviews and that you're scheduling it so that you can sit in on those interviews. And for the non-managerial interviews, just giving those folks a heads up what's going on so that they don't get too nervous about speaking to a representative from the federal government. All right. Now, one quick item I want to touch on here. Some of you may have seen this announcement, and that is we have an updated disability self-identification form. That was issued by the OFCCP. You can get it from their website. I embedded a link here in the presentation. Effective August 4th, 2020, that is the form you need to be utilizing to solicit disability information from your applicants and your employees. And that form cannot be altered. Right? You have to replicate the form, the substance of that form, the font size, the OMB number, all that good stuff. They've streamlined the form so it's on one page, mercifully. One thing that has caused confusion for a lot of employers is at the bottom of the template form, there is a box that says for HR use, right? And that is for employers who are still using hard copy forms instead of electronic copy forms so that they can put any notes that they need to in there. You're not required to put that box on your form, all right? So you don't need to include that. So if you're wondering what it's there for and what you're going to use it for, it means you don't need it. Get rid of it. Okay, so one thing I'll just quickly answer because the question came in while we were chatting is if the majority of our employees work at a customer facility, right? So they're not actually on site with us. Are they going to request a tour of the customer facility? The answer is no. If the facility is outside of our control, we can't really grant access to it for the OFCCP. So in those circumstances, we may be able to negotiate with our customer to allow aspects of the on-site to take place so that there isn't too much of a disruption of operations. But since we're operating in a virtual world right now and everything's going to be done telephonically, we're less concerned about that. And in terms of a tour, the OFCCP will not be touring your customer's facilities. So you just have to worry about your own from an accessibility and a employment posting standpoint. Okay. So moving along, we have 3 new directives that the agency issued at the beginning of the calendar year, 2020, and before everything with COVID-19 struck. And they are an efficiency in compliance evaluations, right? So efficiency in audits, a establishment of a mediation program before the OFCCP pursues litigation, and further clarification of the role and responsibility of the Ombuds office. All right, so let's dive into each of these in turn, and we'll start with efficiency and compliance evaluations. So some of you may remember that a report was solicited by Congress on the OFCCP's effectiveness a few years ago. And there were a lot of critiques that came out of that report, one of which was how long audits take. And that's been a complaint of the contractor community for as long as I've been practicing, and I've been doing this almost 25 years. The agency just doesn't move quickly as a general rule. So the agency put this directive in place recently to try to put some guardrails, if you will, around the timetables for these audits. And just real quick, so you know, there were always timetables. If you looked at the OFCCP's compliance manual, there were timetables for how quickly reviews should take place. It's just that they were ignored. So I'm going to be optimistic that perhaps this directive gets the agency a little better on track. But it is a big government bureaucracy, and we know how that works. So I'm not necessarily sold that we're going to see much in the way of a pickup in terms of the agency's efficiency. But here's what the directive says. The agency's goal is to close audits within 180 days. So basically 6 months, okay? But there's an important disclaimer there, and that is for reviews that close without discrimination violations. All right, so if there's no discrimination issues that the agency has to investigate, then they're going to look to close those audits within 6 months. If they believe discrimination has taken place, they're going to try to issue their preliminary findings within a year, right? So this is the predetermination notice, or PDN. Some of you may remember there was a directive issued a little over a year ago by OFCCP on the use of predetermination notices. And for the first time, the agency actually mandates the use of a predetermination notice in instances where the agency believes discrimination has taken place. So the OFCCP cannot issue a notice of violation for discrimination before a PDN has been issued and the contractor has an opportunity to respond to that PDN. And that's important because I know from experience, and some of you may as well, that when the agency issues a notice of violation, they are loath to overturn it. Even if you're able to show that they're wrong, they hang on to that thing like it's a long lost parent or something. And so the PDN is the best shot that a contractor has for convincing the OFCCP that their conclusion regarding discrimination is wrong. All right. So with that, the agency has said, look, if we're going to accuse you of discrimination, we're going to try to do it within a year with the issuance of a predetermination notice. Now, of course, the agency issued a great, big, huge exception to all of this in that it assumes that the contractor fully cooperates, right? So in other words, if you take a long time to get them information, then all bets are off. We don't have to adhere to these timeframes. Now, of course, they don't say how long is long, right? But basically, this is going to allow the agency to say, yeah, we don't have to adhere to that time frame because, frankly, you really didn't help us. So anyway, so that's what the agency is trying to do here. They're supposedly going to be tracking their metrics, and I wouldn't be surprised, by the way, if at some point, probably within the next year, the agency issues some sort of announcement of how they've shortened the timeframes to complete reviews. So one question that comes out of this is, well, what if these reviews aren't going as quickly as they're supposed to go? What do we do, right? So this is the proverbial, do we poke the bear? Or as we put it, because we regularly advise clients, look, let sleeping dogs lie. The review will conclude when it concludes. And from my perspective, the longer it lies fallow, unacted on, the better the argument you have if the OFCCP comes back and asks for more information to say, do we really need to do this now? You've had this review open for 2 years. Right? But the agency laid out a process in the directive that they expect contractors to follow if they believe that the agency has not adhered to this directive. So you start with the regional director, right? You can even start with the local district office. That's probably a best bet. And you can raise it up if you follow these steps, right? So if the audit is open for 1 year, and there's no PDN issued, take it up with the regional director. If it's been open for 2 years and the case hasn't been referred for litigation, you can bring it up with the office in the regional director. And if it's not resolved by the regional director, you can either contact the director of the OFCCP itself, or you can notify the Ombuds person. All right. Last thing is the agency obviously has full discretion to do with your complaint what it will. So this directive does not establish any rights for you as a government contractor, right? You can't sue the OFCCP because they haven't followed their directive. All right. The next directive relates to pre-referral mediation, okay? So this particular directive deals with instances where the agency has found discrimination. They've tried to conciliate with you as the contractor. You can't reach some resolution. The next step ordinarily is for the agency to issue a show cause and then go to litigation. They've put an intermediate step here, which is that you can seek mediation if conciliation efforts fail and prior to the issuance of an administrative complaint by the Office of the Solicitor. All right, and that's interesting. This is something that the agency really hasn't been open to in the past. They're just getting around to trying it out. And there isn't a lot of experience or track records here. In fact, with the exception of one major litigation case that was not dealt with under this mediation directive, I'm only aware of one instance where the agency and a contractor went to mediation. This directive establishes the protocols for the mediation process, including selecting the mediator, who pays for what, and so there'll be some pre-mediation agreement that's entered into by the parties. One thing, just real quick to point out regarding mediation is understand that mediation is not litigation, right? So the purpose of mediation is not to convince a mediator that you're right and they're wrong, and therefore the agency walks away. Mediation is meant to bring the parties together to some sort of compromise. So you have to be willing to entertain the notion that there'll be some sort of settlement or resolution short of the agency going away and saying everything is fine. And if that is not something that you're open to, then mediation is really just going to be a waste of everybody's time, and it can be expensive. So you should consider any wasted resources on that. All right, the last of the the directives is the Ombuds Service Supplement. All right. So what this does is it further clarifies the role of the Ombuds person. All right. And it also sets out the process by which contractors can reach out to the Ombuds person to try to use that role in a way to resolve certain issues. It's really important to understand what the Ombuds person is for and what they are not for. All right. So the general idea is that the Ombuds person is there to help bridge gridlock between a contractor and the OFCCP. All right. Usually on technical issues associated with compliance evaluations. All right. It is wholly appropriate to raise issues of conduct or misconduct or the agency not following its own procedures to the Ombuds person. That's a really good use of that. If there's a stalemate, if you will, or gridlock over access to certain information in a compliance review, this would be an appropriate forum to raise it. If you think that the agency is acting in a way in a particular review or reviews that is contrary to big picture policy issues at the national level, this would be a place to raise it. The Ombuds person is not there to take sides. They're not going to be weighing in on merits, right? So if you have a disagreement over the OFCCP's preliminary findings of discrimination, you're not going to bring that to the Ombuds person. Don't bring issues of extension denials to the Ombuds person, right? And don't, if you have a disagreement with the agency over a policy that they have, while you can certainly raise your concern with the Ombuds person is not going to overrule the policy people within the OFCCP. All right. That being said, Marcus Sturgio, who's the current Ombuds person, is super nice, very, very interested in making this program work. And so he will do whatever he can to be helpful, but just understand that some of his ability to do things is going to be limited because of the nature of the office. Okay. All right. The last item that we want to touch, and for some reason the PowerPoint is not moving, so I apologize for that. Must be some connectivity issue. But the last thing is what to expect. Great, if you can move it to the next one, unless maybe it's mine that's not showing it. Anyway, what to expect after the pandemic, all right? Well, look, compliance evaluations are going to continue. The agency is going to continue to focus on the things that they have always focused on, but now we have a couple additional things to be on the lookout for. One is adverse impact issues associated with decision-making related to COVID-19. Things like who you decided to furlough, who you decided to lay off, who you decided to recall. All of those things can be analyzed for adverse impact patterns. We recommend that you do that because the agency may very well be looking at that during audits going forward. The other major thing to be on the lookout for is accommodations. And this is a really confusing space because accommodations ordinarily, right, are for a person's disability, right? So when somebody comes to you and says, look, I'm not comfortable coming back to work because I have a newborn baby at home, right? That's not a traditional Section 503 accommodation. But might there be certain requirements around accommodating that type of request? That's an issue for a whole nother day. In fact, if you're interested in knowing the answer to that types of questions, we have a webinar that we're doing next week for Jackson Lewis, a quick hitting 20-minute webinar on just these types of requests of accommodation now that we're dealing with returning to work after the shutdowns associated with COVID-19. So again, if you're interested in that, more than happy to chat with you about it offline. You can shoot me a note. I can send you the link, or you can go to the Jackson Lewis website at jacksonlewis.com and look at programs. All right. The last thing that I will mention is that on-sites, I think, are going to become increasingly rare as the agency continues to work from home. I was on the phone with a couple compliance officers this morning. They tell me there is no direction as to when they're going to return to work, so they're all working remotely. So there aren't going to be on-sites while they're working remotely. Moreover, even once they go back to the office, I just have a feeling once they see that they can accomplish most of what they need to accomplish virtually, it's really going to eliminate the need for on-sites. Okay, so that's what I would expect going forward in all of this. And with that, I'm going to wrap up the presentation portion of the program. I apologize. I am currently not in the actual web